Good morning. I'm Will Salas from the Smithtown Library, and today we're going to discuss intellectual property protection. So the reason I'm discussing this with you is because I am the representative for the Smithtown Library for the Patent and Trademark Resource Center. So if you're watching this, you might be having an idea and wondering how you can monetize it or do something with it. The first thing you want to probably do is protect your idea. And what I'm going to discuss during this video will help, but you're going to probably need a little more help along the way. And if you're starting a business or hope to start a business, it's a good idea to build a team around yourself. One of the things you can do is visit with me at the Smithtown Library. On screen, you have my address, Smithtown Library, and my email address and phone number. When you visit with me, I also share a lot of information about other nonprofit government businesses and organizations that'll help you with some of the things that I cannot help you with. A couple of things I can't do is give any legal or business advice. But again, I have a list of organizations that are out there to help people who are beginning a business or trying to protect their idea or start some kind of an organization built around their idea. In any case, some people believe that inventors are just people who work in lab coats, white hair, glasses, look like Einstein. Not the case. I believe that anyone can be an inventor, and because we see things differently, you look at things differently, you might have a different solution to an issue that might lead to an invention. Here's a couple of for instances. What you're looking at now is a young boy named Richie Stokowski. At 11 years of age, he was very lucky to go to Hawaii on a family vacation. So he was surfing with his dad, and they go underwater, and Richie sees all these beautiful sights, coral, fish, colors, and he looks over to his dad and he tries to speak to him, realizes that his voice is all garbled and you cannot speak underwater. Well, he's a very industrious young man, so he gets to work and he starts to build his own underwater walkie-talkie, and he invents the water talkie. He winds up having a meeting with the people at Toys R Us. This is going back a few years. And at the end of his meeting, he winds up selling 50,000 units of his water talkie. All of a sudden, he sells his business a few years later for almost $1 million. Okay, so for another example, this is a young man here. His name is R.J. Batts. His father was a chef and would often come home with cuts on his knuckles and fingers from chopping vegetables. So R.J. decided that he would build a little device that would help protect his father, and he called it a tip tuff. And basically it's a little shield that protects his father's fingers from being cut by the knife that he's chopping with. So the idea is that where do good ideas come from? The best ideas usually come from solutions to problems. And if it is a problem that many people experience and you come up with a new, unique way of solving that, you may be on your way to having an idea that can be patented and possibly commercialized. So here's another situation. We have a faucet with cold and with warm, but he wants more decisions, and he wants to, so this person decides to invent something because he wants to make up his own rules. Well, that's the kind of a way that an inventor thinks. They have to look at things differently and come up with solutions to problems. And if you can do that, you may very well have an idea that could lead to a patent. But full disclosure, not all ideas are good ideas, and to be honest, 90% of the ideas that are patented don't even make their way to the market. And of that 10% that makes its way to the market, not all of them are commercial successes. So just so that you're aware of what you may have ahead of you. Now, these ideas that you have, whether it's for inventions or other things, the term for them is intellectual property. They're your ideas, and you alone can do something with them so long as you keep them from being used by others. And how to do that is, well, first, you want to keep it a secret. Don't tell anyone until you have some kind of protection, intellectual property protection. So there are 4 different flavors of intellectual property protection. I will go over each and go into depth with a couple of them. So again, to protect your idea, you're going to protect it with intellectual property protection. Now, just like you own property, physical property, how do you protect your physical property? Well, you might keep it in your house, and maybe you lock your doors and windows at night, you build a fence around your home, or if you bring some of your personal property to your work or school, you probably have it locked away safely. Well, you really can't do that with ideas. You can't lock your ideas away in so much as you can physical property. But again, there are 4 flavors of intellectual property protection. The first one you probably had heard of is copyright. Copyrights are great for artists. It helps protect original works of authorship. It protects the expression, but not the ideas behind it. And the authority behind copyright protection is the Library of Congress. Some people who enjoy copyright protection are artists, software designers, authors, and your filmmakers. The next kind of intellectual property protection is a trade secret. Because you come up with an invention, you are not obliged to patent your idea. If your invention or your idea can be kept a secret, let's say it's not so much in the product that your customers will be able to reverse engineer and open up and look inside. Maybe it's something along the assembly line, and you can keep it a secret. Lots of trade secrets are recipe related. As long as you can maintain that secret, you can keep it indefinitely. Some companies that enjoy trade secrets are companies like Coca-Cola, WD-40, and Kentucky Fried Chicken. The wonderful thing about trade secrets is, as long as you can keep it a secret, it can be kept indefinitely. Next, you have trademarks, and we're going to go into a little bit in depth with trademarks. A trademark is something that companies use to help its customers identify who is making that product. So if they're a good company and they have a good reputation, they are going to have a lot of people and customers looking for their products based on that word or name or symbol that appears on the product. Now, there are different levels of trademark protection. You may have seen this symbol, the TM. The TM stands for trademark, and that is free to use. That's called common law protection. Anyone's allowed to use that. And when you use that, you're just warning others in your industry that you are interested in protecting your intellectual property and to back off. You may have seen the SM. The SM stands for service mark. They kind of fall both under the umbrella of trademarks, but technically service marks work for services, your hairdressing, taxes, lawn services, whereas the TM is more for your tangible goods. In any case, those two are free for anyone to use at any time. However, the goal is to register your mark with the federal government and receive the encapsulated R. That signals that your mark is registered with the United States Patent and Trademark Office, which is the authority when it comes to intellectual property protection. And anyone who uses a mark that has the encapsulated R next to it would be infringing upon that trademark's owner. Now, there are many different kinds of trademarks. Some of them may just be logos or symbols or designs. And as you might see here, we have the McDonald's Golden Arches, the Nike swoosh, and the Apple icon. These companies spend billions and billions of dollars to ensure that you recognize these symbols because they realize that consumers are trained to look for them. So this is a very big industry. Some folks argue that trademarks may be a more valuable asset to a company than a patent. There's also trademarks that are called composites. Earlier, you saw just symbols. These trademarks have both lettering, as in the Starbucks example here, Starbucks coffee, as well as the mermaid inside, both symbols and lettering. And of course, you see the encapsulated R. Trademarks can be a little tricky sometimes. They come in all kinds of varieties. UPS is actually able to trademark the color brown for its delivery vehicles. Pizza Hut was able to trademark its rooftop so that people who see that rooftop driving through a town recognizes that, and they realize who makes those, who owns the restaurant and what they're in for. There's also something called sensory marks. You can actually trademark sounds. And I like to play these for people just to give an illustration of how well they've been trained already without even knowing it to recognize these trademarks. So I'll play a few for you. All right, that was an easy one. Aflac Insurance Company. Then we have all right, for your film fans, that's the MGM Lions. Oh. That's our Pillsbury Doughboy. Okay, sports fans will recognize that as the ESPN chime. And then finally, okay, big Bugs Bunny fans will recognize that as the Looney Tunes. The point of that little exercise is to make you aware that companies that do spend all these millions of dollars and billions of dollars in advertising use this tool, trademarks, to help customers recognize who is the source of the product in hopes of enticing you towards their product. And again, some people argue trademarks are a more valuable asset than patents. For instance, Coca-Cola may not be the best tasting cola out there, but they are certainly more recognized around the world than most any other drink out there. And it is because of that big campaign of advertising and trademarking that they are as successful as they are. Now, one of the things that you may want to do if you are interested in registering a mark with the United States Patent and Trademark Office is what they call a clearance search. You want to make sure that no other company in your industry is already using that mark before you go out and buy a domain name and spend the money on products and paperwork and such. You want to make sure that that symbol or name or logo is free to use. Now, again, there are 3 different levels of trademark protection. The first level is common law. So what common law means is that you're already eligible to use the TM or the SM to signify that you are interested in protecting that logo, name, or symbol. But common law means that even stores that are just startups or mom and pop stores, people who are not even aware of what a trademark is, they have rights already. If they were using a mark before anyone else, they have rights to continue using that mark and excluding others from using that mark in that industry. So those are for your mom and pop stores and your startups. There's also state level trademark. If you're doing commerce, let's say just in New York State, perhaps a small chain of restaurants, then you can file for trademark protection in New York State. It's fairly cheap, it's about $50, and it's done by the State Department. They will actually do a search for you within New York State to see if anyone else is already using that. If you need more help with that, you can contact me or visit me with me at Smithtown Library. We can go over some of that. But of course, the best level of protection is your federal trademark. That will assume that you have that business protected throughout the United States, and you can actually file your trademark with the customs agency to stop any knockoffs or bogus products coming into the country with your trademark on it. Now, a word about trademarks. The trademark office wants to make it fair for everyone to trademark their goods. But of course, you're going to probably run out of trademark symbols if you just give the symbol, if you just trademark and register something for a particular company and then stop all the other companies in that industry from using it. For instance, there is 2 different companies, and they're both called that product called Dove. You have Dove chocolate bars and Dove soap. Now, nobody's going to bite into a bar of soap thinking it's chocolate or vice versa. So these companies, they're both called Dove, and they both have a Dove symbol, but they get along famously. And the reason that is because they are in different international classes. International classes are a listing of 45 different groups of industry, and it's more of a guide than a strict classification. what you want to do is make sure that nobody in the same international class as you are going to be in has the same symbol. So what happened was the big companies around the world, the big countries around the world got together in Nice, France, and they hashed out 45 classes of industry. So this way they can give out a trademark to a company like Dove soap, and they don't have to worry about stopping other companies that have nothing to do with soaps from using the word Dove. So this way you have Dove chocolate bars or Dove tennis shoes or Dove tires. They can all get along famously. And this way everyone's protected, and other companies that have nothing to do with the Dove chocolate bars or Dove soap can get along. Now, once again, the authority for trademarks in the United States is the United States Patent and Trademark Office. They have a database called the Trademark Electronic Search System. So if you're looking for a trademark, it's a good idea. If you would have a mark and you would like to register it, it's a good idea to do a clearance search. Even if you're not looking to register your mark and you just want to use it, it's a good idea to perform a clearance search for your mark in the Trademark Electronic Search System, as well as looking for state-level trademarks and common law marks before you invest into that name, symbol, or logo, because you don't want to start a business with a logo, then wind up getting a cease and desist letter from another company that had already been using that particular mark in that industry. To help you along with that, you can visit with me, again, at the Smithtown Library, and without giving any business or legal advice, I can demonstrate for you how to go about performing a search for your mark in the Trademark Electronic Search System. And again, without giving legal advice. So I don't do a search for your particular mark. We use a sample search, and then you can apply that to your symbol. So far we've discussed 3 of the 4 intellectual property protections: your trade secrets, copyrights, and trademarks. So moving on, we're going to discuss patents. So a patent for an invention is a grant given by the government that's going to exclude anyone from making, using, selling, importing that inventor's device in the United States and its territories. That's really important to remember, United States and its territories. A lot of inventors find out the hard way when they receive a US patent, they decide to manufacture their products overseas, let's say Mexico or China. Now, if that Chinese or Mexican manufacturer is really fond of your invention or your product, he might make the 100,000 units that you had ordered, but he or she may also make another 100,000 units and go ahead and sell it in his country or elsewhere. And that would be perfectly fine, because you are not protected around the world everywhere when you get a US patent. Again, you're only protected in the United States and its territories. Now, you do have the option of protecting yourself in other countries by filing for patents in that area. Some patent offices are country specific, like the United States Patent Office or the Japanese Patent Office. Some patent offices are regional, like the European Patent Office. There are over 30 countries involved. So it is up to you to decide if you want to file for patents elsewhere. And again, there is no international patent, simply because the countries of the world just can't seem to come up with a consensus of how to go about doing that. Now, are patents important? Well, let's have a quick look here at this classroom. And this classroom, all of these numbered items have been patented. And generally, it doesn't have to be a classroom. Here are some more items around this classroom that have been patented. But if you just look around the room that you're sitting in, no matter where you are, it's most likely that there are several items around your room, wherever you may be, that have been patented. Patents just come about because people are looking to improve life, make life easier, and these devices become patented because these inventors who go through the motions of trial and error and making all different kinds of prototypes, that costs money. So to reward those inventors for all the trouble they go through and the companies they work for, patents will allow them to reap the rewards of their invention because it would exclude others from using that technology. So the give and take of patents. What does the inventor get? Well, again, you get a government grant where it gives you a 20-year legalized monopoly that you're the only one in the country who's allowed to use that device. You can the only one allowed to make it, use it, or import it, or sell that invention. A little later, we're going to talk about design patents. Design patents last for 15 years. But it's a two-way street. What does the government get? Well, you have to fully disclose how your invention works. And that becomes public domain. And the reason that becomes public domain is that the government wants others to look at your ideas. And that sounds very much not like what you would like to have to happen with your idea. But that's what the government gets. You're protected, but others can learn from and innovate by taking a look at how your invention works. Other tinkerers, inventors, entrepreneurs can learn from and continue innovating. And innovation stimulates the economy. So the government gets a stimulated economy. People can learn from your idea and perhaps try to build something bigger, better, faster. But in the meantime, you are covered for your invention. So what does a patent look like? Well, let's have a quick look at an invention here. This is a patent document. I'm going to click on full pages here so we can take a quicker look. All right, a really quick tour of the anatomy of a patent document. The patent number is just chronological order. The next patent that comes out may not have nothing to do with this invention. It'll be just one number higher. This is the date that it was patented, not to be confused with the date that it was filed. An inventor who is granted a patent will receive 20 years from the file date. In this case, it'll be 20 years from 1993. The titles of patents are really bland, so title searching is not very useful when you're trying to see if anyone has already beaten you to the technology. And the reason you want to do a patent search, I'll go into that a little more later, is that to receive a patent, you have to be the first person in the world to have thought up that idea. Okay. Over here, we have an abstract. An abstract is just a summary of what the patent is about. And then finally, over here, you have the drawings. The drawings are very helpful for inventors who are performing a clearance search. And if you haven't guessed already, what this patent is protecting is the fidget spinner. So this is the patent for the fidget spinner. Now, the reason I bring this up is this is kind of a sad story. The inventor is a woman from Florida. Her name is Miss Hettinger. And she actually decided not to continue with the maintenance fees for her patent. You pay a 3.5, 7.5, and 11.5 years to maintain your 20-year patent. If the patent's not going anywhere and you just don't feel like continuing to protect it, then you can stop making payments and you lose your protection. No one else can patent it, but you are no longer able to exclude others. Sadly, Ms. Hettinger had stopped making her payments. I think she had some financial hardships, and a few years later was when the fidget spinners really took off, and she missed out on millions and millions of dollars, sadly enough. But there are lots of good success stories as well, not to scare you off. So when it comes to patents, there are really three different types of patents. 90% of the time when people are discussing patents, they're discussing what's called a utility patent, which is a brand new use, a new process, a new machine, a new article of manufacture. I had an example of an article of for instance, an article of manufacture would be this pencil. There are no moving parts. So I'm often asked, what is article of manufacture? A new machine or an improvement upon an existing patent. Most patents these days are improvements upon previous patents. If you can make something better, bigger, faster, more efficiently, and that change is different enough from the original, then you may be able to get a patent for that change. So the next type of a patent is a design patent. When you see a design patent, the number is preceded with letter D, and what a design patent protects is the ornamentation of a device. I always think of Steve Jobs when it comes to design patents. Steve Jobs didn't invent the inner workings of the iPod. He just gave it those really curved lines and cool looking buttons, circular buttons, and curved corners. So Steve Jobs had plenty of design patents, not utility patents. The third type of patent is a plant patent. Any asexually reproduced, distinct new variety of plant can receive a plant patent. When you look at a plant patent number, it's preceded with a double P. And it's exactly what it sounds like. Any kinds of new fruits, berries, shrubs, trees, roses can receive a plant patent. So the requirements for patentability, you really have four. The first, it has to fit a statutory class, meaning it's got to be a new process, a new machine, article of manufacture, a new composition, or an improvement of the previous four. Very difficult not to meet that requirement, so that doesn't really become much of a hang-up for anyone. Secondly, it has to have some utility. There's got to be some functionality to it. You can't just put a bunch of nuts and bolts together and say, look, I have a new invention. Some people are very vain and they want to add a patent to their trophy room, but that's not that simple. You put a bunch of nuts and bolts together, like I said, that's called sculpture. It's not a new invention. Thirdly, it must be new to the world. It must have novelty. It can't have any previous publication of your technology. And when you're doing a patentability search, what you're looking for is called prior art, any previous existence of your invention. And it's worldwide. So when you file for that patent for that brand new mousetrap that you invented, your patent application will wind up at the desk of someone who is an expert on mousetraps. And he and she will scour the planet for any publication having to do with your technology. He and she will know all the trade shows, the magazines, and certainly all the patent offices. And if they find something that was published in an Argentinian graduate school newspaper that includes your technology, that may be enough to deny you a patent. And lastly, it has to be non-obvious. Now, what do they mean by non-obvious? It's a little difficult to explain. A good example is, let's say a new type of aluminum metal came out, a new variety of aluminum, and you make bicycles. So you decide to be the first one to build a new bicycle frame using that new metal aluminum. That's not going to qualify as a patent because it was kind of obvious. It was kind of going to be the next step. If there's a new kind of metal out there that can be used by manufacturers, it's not that you're really inventing something new. There's no surprise element there. Somebody who's somewhat skilled in the art of that industry would probably have foreseen that new metal to be used in that industry. So it would not have any kind of a new surprise element that can be considered an invention. Now, like I said, your patent has to be new to the whole world. So when you visit with me, I go over what's called a preliminary patent search. Now, what that means is the United States Patent and Trademark Office teaches me and shows me how to demonstrate how to perform a preliminary patent search. And what that means is searching the big three patent offices around the world: the American Patent Office, United States Patent Office, the European Patent Office, and the Japanese Patent Office. After you've searched those three big patent offices and you do not see any hint of your technology, then you'll be better informed about whether or not you want to make a financial investment into this product or idea of yours. Patent offices can be used by most anyone. Inventors, obviously, we have a couple of databases at the Smithtown Library Patent and Trademark Research Center that are used by attorneys. We have professionals, entrepreneurs, most anyone who has an idea. Like I said, inventors they come in all kinds of varieties. So anyone who has an idea is welcome to come and visit with me, and I will go over how to perform a patentability search. Or if you have a business and you want to protect your mark, I could help you with that as well. So since we're coming up on Easter, and just to demonstrate that patents don't have to be as technical or scientific as some people assume them to be, they can be patents for inventions for most anything. So here are a few examples. Here is a patent for an item called the hinged plastic Easter egg, which sounds simple enough, and I'm sure you will all recognize it. And sure enough, here is the patent document, and you might recognize it right away. There it is, the Easter egg that you may have come across as a child or a parent. believe it or not, that Easter egg was at one point patented. There's Easter egg dyeing and drying device. So someone decided to go ahead and invent a device for dyeing and drying Easter eggs, and they received a patent for it. Here's a design patent. I know it is a design patent because it has the letter D, for a set of toy bunny Easter egg ears. And again, the purpose for me to show you these patents is just to give you an inkling of what is being patented out there. It doesn't have to be a world-changing idea. It could be something simple. But some of these simple ideas become market successes. Again, the flip side of that is often these patents just wind up something to be proud of and put on your mantle, but maybe never makes it to the market. And finally, a plant patent, I know that because of the double P preceding the number, for this orchid called Easter egg. Now, the plant patents are very interesting. The plant patents are the only documents that still arrive at Patent and Trademark Resource Centers in paper format, in hard copy. Everything else has been digitized, and thankfully, because if everything still came in paper format, trademarks and regular patents, then we wouldn't have room in the Smithtown Library for a PTRC. But if you're ever interested in taking a look at some of our plant patents, we have filing cabinets full of these brand new variety of trees, shrubs, flowers, fruits, and berries. So in the future, there are going to be certainly many more inventions that will make their way into your home, and who knows, you might be the one who are inventing and patenting them. And if you do have that idea for a new invention or word, symbol, name, or logo for your industry, for your company, please do consider seeking intellectual property protection to protect your idea. And if you do, please come and visit with me. Again, my name is Will Salas. I'm at the Smithtown Library. This is my contact information here, and I'd be happy to go over the patentability, or I'd be happy to help you search for your mark at the Trademark Electronic Search System. So thank you for joining me today. We cannot wait the library for our buildings to open soon and see you there. But until then, stay well and continue to visit the library's website at www.smithlib.org. I spell SMITHLIB.org for more programs and resources. Thank you.